Another issue that I've been watching with deficient NTAs through the circuits, and it's picking up steam, and it's something I was touching on in the crimmigration piece I did for your magazine, which I love. Not my piece, but your magazine. United States v. Myers in the Eighth Circuit. And as I said on social media at the time, the Eighth Circuit, and this is not an immigration case, but the sentence enhancement case is applied to immigration when they apply the categorical approach. Eighth Circuit is adopting the isomer argument, and somebody correctly informed me on Twitter that the Eighth Circuit already had, but I didn't know about it. So to me, they're adopting the isomer argument, and that is that Missouri's definition of cocaine, in 2003 at least, was broader than the federal definition of cocaine, because Missouri criminalized all types of cocaine isomers. I don't even know what that is. I guess it's a chemical. And the feds only criminalized optical and geometric isomers, not positional isomers.
Remember, Ninth Circuit had a situation like this too a couple years back that the
Ninth Circuit did, and then they got cold feet and they revoked it. So the Ninth Circuit was way ahead of the curve there, but then they got scared. I don't know what any of those isomers are, but it doesn't matter. Federal is the Missouri version is overbroad vis-a-vis the Fed, and the cocaine's not divisible. You're not going to get a conviction, for example, where the prosecution proves the isomer, which means that it couldn't be used to enhance the sentence. And it would mean to me, and really I don't see how I'm wrong, that Missouri cocaine possession from at least 2003, whenever the definition was, is not a law relating to a controlled substance violation, cannot be a drug trafficking aggravated felony, is not a drug inadmissibility provision. I mean, it's crazy. And so holding the Eighth is aligning with the Seventh without saying it. The Seventh made a similar holding last year on meth. So you got the Seventh and the Eighth completely all in on isomers and the chemical divisibility of these statutes. You've got the Ninth Circuit, you've got the 11th Circuit kind of agreeing with it in one of their decisions last year, but saying you didn't prove to us that the isomer exists, which whatever. But the implication is that if you had proved to us through a different expert report, we would agree. That's the implication, at least. So like this is gaining steam. Not to mention the 11th Circuit has held that Florida's definition of marijuana is overbroad, as the 8th Circuit has similarly held with Florida marijuana. That is, Florida is criminalizing possession of the seeds and the stalks and the stems, whereas the feds only care about the smokable portions. So not an isomer argument, but similar, and the 11th has held it, that these drugs can be overbroad themselves. Not just that the state criminalizes more drugs, but that the drugs that they do criminalize are broader than the feds. And that is just, that's a big argument, and it's gaining steam. And so I mention it whenever it comes up, and it came up last month. The United States v. Myers.
You know, I always say like immigration touches upon every aspect of other fields of law, like immigration and like all these different things that may pop up. Investment based has contracts laws and all this kind of stuff. But it touched on normal life too, and chemistry wasn't one I would like jump out and say like chemistry applies in immigration. There's chemistry factors that come in. So fascinating area of law that we're in.
Yeah, no, you gotta have a chemist now to go. You gotta hire. There's a lot of country condition experts. The chemists are going to become just as important. You need to find a chemist for an expert opinion. I mean, that's not even being facetious.